consumer welfare and the efficient functioning of consumer finance markets. I am very pleased to introduce our panelists, all of whom I know. Nancy Weisgold, my colleague, is co-leader of the Alston & Bird's Financial Services and Products Group in the firm's Consumer Financial Services team. She maintains a national practice focused on matters relating to consumer financial products and services, represents clients, including mortgage servicers, well banks, non-bank consumer lenders, technology providers for the consumer financial services industry, AMCs, and investors in federal and state regulatory, supervisory, and enforcement matters. She acts as regulatory counsel in connection with investments or acquisitions, performs compliance due diligence. Nancy is frequently called upon to provide litigation support and assist in the development of compliance management systems. Professor Todd Zwicky is George Mason University Foundation Professor of Law at George Mason University Antonin Scalia School of Law. He's also the Senior Fellow at the Cato Institute. He's the former Executive Director of George Mason's Law and Economics Center. In 2020 to 2021, he served as the chair of the Consumer Financial Protection Bureau Task Force on Federal Consumer Financial Law, and in a prior life, served as the director of the Office of Policy Planning at the Federal Trade Commission. Professor Christopher Peterson is the John J. Flynn Endowed Professor of Law at the University of Utah's S.J. Quinney College of Law, where he teaches contracts, commercial law, and consumer protection courses. He was on leave from 2012 to 2016, serving as a special advisor in the Office of the Director at the CFPB, in the Office of Legal Policy for Personnel and Readiness at the Department of Defense, and as Senior Counsel for Enforcement Policy and Strategy in the CFPB's Office of Enforcement. He also works as a consumer rights attorney for, attorney for U.S. PERG in D.C. and clerked for the Honorable Wade Rohrbree, sorry, I'm going to butcher that name, on the U.S. Court of Appeals for the 10th Circuit. It is an honor to speak with you all. Thanks very much to each of you for joining our discussion for the third hour of this conference. Welcome, everyone. So the first prompt here, I think the best way perhaps to spend our time thinking about the future of the CFPB is maybe to bifurcate the discussion and talk about first, what do we know about the CFPB's new leadership and what should we expect from a policy and activities perspective? And then maybe take a step back after exploring that area and think about the more normative question, which is, okay, we understand, from during this conference, the actions that Director Kraninger took and the actions that the Bureau took in the first 10 years. We have a good understanding maybe of where the Bureau will be going in ensuing months. But stepping above that fray a little bit, what should be the future direction of the Bureau? Where should its enforcement and supervisory or rulemaking priorities lie? What should shape the policy development for the agency going forward? And each of you are experts in your field. Think about this practice in these areas, and so think about it from different perspectives. And I really anticipate that this will be a very interesting discussion going forward. So, with that game plan in mind, let's tackle this first question here, which is, what should expect from the CFPB's new leadership? And maybe the best way to start is to take new leaderships at their word in terms of what they're saying their priorities are and what they intend to do moving forward. And there's been no shortage of that type of communication over the last 6 months. So, Nancy, why don't I turn this over to you first, and would love your thoughts on what the Bureau's priorities are now, what you are hearing from leadership and the direction of rulemaking or enforcement and policy development from the agency going forward.
No, absolutely. Thank you, Brian. And thank you, the Federalist Society, for inviting me. Delighted to be here today. So at the Bureau, as we know, we have acting director. We don't have the confirmed director yet. Actor Director Uigio has written quite extensively about his priorities. So he's articulated two main priorities. The first one is the relief for consumers facing hardship due to COVID-19 and the related economic crisis. And the second one is addressing racial equality. You know, with 6 months under our belt, the acting director has written fairly extensively, or I'd say extensively, about these priorities. And I also have observations with working with several companies in front of the CFPB and how they translate. So let me share some of those thoughts. And as Brian said, I'm going to focus on supervision and enforcement, consumer education and outreach, and rulemaking initiatives. Starting with COVID-19, we're already seeing a shift to more aggressive use of supervision and enforcement tools and overseeing companies responsible for COVID relief. As Brian said, I represent a lot of mortgage servicers, but I also engage in student loan services and my partners in auto loan services. We also work with banks that are taking PPP applications. And in all of those areas, what we see is that the acting director has directed supervision, enforcement, and fair lending to always determine the full scope of issues found in exams, systematically remediate all of those who have been harmed, and require companies to change policies, procedures, and practices, you know, to root causes of those harms. We are seeing that today in the form of MRAs, which are matters requiring attention that are sometimes issued with regards to examinations. Second, in May 2020, the CFPB supervision program conducted priority assessments in response to the COVID-19 pandemic. And priority assessments were slightly different than examinations, and they were designed to receive like information from a broader group of supervised entities and kind of look at bigger picture issues. Now what we're seeing is the initiation of more targeted follow-up of exams of issues identified in those prioritized assessments. So we're seeing lots of companies getting information requests for examinations. They've also called for, the directors called for the expedited enforcement of investigations relating to COVID. And in this regard, and I'll say I don't see this as necessarily COVID related, but with regards to investigations generally, we're seeing the increased use of investigative hearings, you know, which is basically a deposition to basically speed up the enforcement actions. The last two things I'll note quickly on supervision and enforcement is the acting director has indicated that he is directing to reverse policies of the last administration that supposedly weakened enforcement and supervision, as well as to supervise lenders with regard to the Military Lending Act, presumably I would say under the UDAP authority to do so. With regard to consumer education, you know, I routinely advise my clients to mine consumer complaints to identify consumer weaknesses and systemic risks. I also tell my clients that the Bureau loves to turn complainants into witnesses. And that is so true today. The acting director has advised the Consumer Education and External Affairs to, and I'm quoting here, redouble its efforts to ensure the Bureau engages all consumers who are economically suffering, ensure that consumers who submit complaints to the Bureau get the response they deserve. So I think complaints are going to continue to be very important to watch. In addition to preventing another foreclosure crisis, the Bureau is laser focused on tenant evictions. The acting director advised the Consumer Education and External Affairs to target Bureau resources to reach and help consumers in delinquency or at risk of foreclosure, as well as renters at risk of eviction to know their rights. Also to ramp up coordination efforts with other agencies to help to help provide information to at-risk homeowners and renters, as well as making sure that homeowners and renters can utilize how to prove housing counseling organizations to kind of manage those risks. And last, with regard to rulemaking, we've already seen a focus on mortgage servicing. With the rulemaking was recently finalized on June 28th with an effective date of August 31st. Among other initiatives in the rule, it includes a temporary special COVID-19 loss mitigation procedural safeguards that are in place before a servicer can initiate first legal action for either judicial or non-judicial foreclosures with certain exceptions. And the Bureau is also exploring options preserving the status quo with regard to the debt collection rule. Final rule Reg F was promulgated last year, but its effective date has been delayed, and we'll see if it does take effect. Next, turning to addressing racial equality, the acting director has indicated taking bold and swift action. He indicated to elevate and expand existing investigations and examinations and address new ones, to add new ones, I should say, to address inequality. We are already seeing broad information requests and fair lending examinations. And personally, in my practice, I've seen several with regard to mortgage originators, mortgage servicers, as well as student loan originators and servicers. Fair lending enforcement is a top priority. And we are already assessing companies with regard to fair lending enforcement actions. I think the first one literally came out within days after President Biden was sworn in. And then the CFPB has indicated that they're even taking a broader look beyond fair lending to identify, root out unlawful conduct that disproportionately impacts communities of color and other vulnerable populations. And I'll get back to that one in a minute, because I think that one's very interesting. With regard to consumer education, they are redoubling their efforts to ensure that the Bureau engages all consumers who are maybe economically suffering, and ensuring that consumer who receive complaints get the responses they deserve. So again, focus on complaints. Secondly, in order to, as they put it, reorient work squarely on consumers, the acting director directed Consumer Education and External Affairs to lead a refresh of the CFPB's website to focus on consumer rights and expand social media presence, to signal that the CFPB is on the consumer side, aggressively rebuild and repair CFPB relationships with consumers, civil rights, racial justice, and tribal and indigenous rights groups, as well as to collaborate with coalitions of stakeholders, including consumer advocates, civil rights groups, grassroots, community-based organizations, and individuals, consumers, to get to messages out to homeowners in the language and terminology they understand, which is looking at limited English proficiency issues. And last, on consumer education, the CFPB noted that consumer advocates have found disparities in companies' responses to Black, Brown, and Indigenous communities, and the acting director has asked the consumer response to prepare a report highlighting companies with a poor track record on this issue. And this analysis will be published. So more to come on that one. I don't have a sense of when that will be published. And then last, with regard to rulemaking efforts, there's a few here worth highlighting. I think I got 3 or 4, all of which are mandates under the Dodd-Frank Act. So the first one, and we talked a little bit a second ago about looking beyond, looking at fair lending more broadly to determine root out unlawful conduct. And I think this one at least goes to that area. So Section 1473 of the Dodd-Frank Act requires the CFPB, along with the Board of Governors of the Federal Reserve, Office of Comptroller of the Currency, FDIC, NCUA, and the FHFA, to develop regulations to implement the amendments of Section 1225 of FERIA concerning appraisals. And specific, this one is the FERIA require implementing regulations on AVM, automated valuation models. We have seen a lot in the press recently with regards to homeowners complaining discrimination in the appraisal process, and that borrowers in historically Black neighborhoods, properties are undervalued. And one of the things in the appraisal community that we see is that there could be appraiser bias. And one way to counteract that are looking at these hybrid appraisals, which would basically be an inspection of the property plus an AVM. So I think this AVM rule is important. Clearly, it hasn't been a focus for the last 10 years, even though there's a mandate in the Dodd-Frank Act for it. And I think that we're going to see renewed attention on that one. Also important are two ones that Director Kraninger highlighted when she spoke with Brian earlier today, implementing 1071 of the Dodd-Frank Act, which amended the Equal Credit Opportunity Act, ECOA, to require financial institutions to collect and report certain information concerning credit applications made by women-owned, minority-owned, and small businesses. So the next action there is a notice of proposed rulemaking. Third, Section 1033 of the Dodd-Frank Act, known as the Open Banking Rule, provides that subject to rules by the CFPB, covered persons shall make available to consumers upon request transaction data and other information concerning a consumer financial product or service that the consumer obtains from that financial institution. Just, I think it was last week, President Biden issued an executive order, and in that order, it encouraged the CFPB to consider promulgating rules to facilitate the portability of consumer financial transaction data, so consumers can more easily switch to financial institutions and use new innovative financial products. I believe the Bureau issued a proposal with regard to 1033 in 2020. And I believe that the next action on this is in April of next year. But Brian, keep me honest on that one. And I think this is one that's going to get significant attention. The last one that I want to highlight, which is not yet a CFPB initiative, I didn't see it in their rulemaking, but I think it should be on folks' radar to watch, is the Housing and Urban Development announced on June 25th, proposed rulemaking entitled HUD's Discriminatory Effects Standard, basically a proposal to rescind the department's 2020 disparate impact rule and restore to the 2013 discriminatory effects rule, as HUD believes that it's more consistent with the decades of case law, including the Inclusive Communities case. So this may be instructive how the Bureau may consider amending Regulation B to ECOA, which only minimally addresses disparate impact. As we have more going to have a focus on fair lending, you would think that would be something that they may be taking a closer look at. So that's a lot. So I'm going to pause right there and turn it back to Brian.
Thank you, Nancy, for that rundown. I think it's fair to say the Bureau has been busy over the last 6 months under interim leadership, which is somewhat unique. If you're expecting a caretaker, Dave Weggio is not that, and I think has proven that. Let me turn it over to the professors and maybe ask the same question a different way, which is, other than maybe the mandatory rulemakings, which undoubtedly will remain part of the agency's agenda, if Rohit Chopra is confirmed as the next director of the Bureau, do you think that those two main priorities articulated by Acting Director Weggio will remain the same, or do you expect that they will change? I'd hazard a guess myself, but I will confine myself to being a moderator of this discussion. But Professor Peterson, why don't I turn it over to you? Mr. Chopra, you've worked with him, I think, on 2 occasions. What do you expect his priorities to be? Is it going to be a continuation of the course that Acting Director Weggio has laid out with maybe an overlay, or do you think there'll be a wholesale change?
Well, thanks, Brian. It's good to be here, first off, and tast you for the invitation to the Federalist Society for putting together this conference. Also happy to be here with Nancy and Professor Wiggy Todd. I do know Rohit. I don't want to overstate that. I mean, we're not besties, but we worked together at the CFPB back during the Cordray years, and we also both worked at the Consumer Federation of America, me on a part-time basis while I was teaching. And I think after he was appointed to the Federal Trade Commission, they were looking for his replacement. And I guess that was me. Some things about Rohit. First off, he is very smart. He is a very smart guy. And he has sky-high EQ. He's very intuitive and understands what's going on in the room. I've never played poker with him, but I anticipate he'd be a very good poker player if he gave it some effort. And he's also very compelling in meetings. Some people, I struggle with meetings because I get impatient in them. Rohit is very effective at working a room in a meeting. He also, in my view, has sky-high integrity and is very sincere in his commitment, which is utterly genuine, to try to make the country a better place and to use government to be a positive force in the daily lives of working people. It's not for him. I do not believe that it's about careerism. It's about making a difference for working people. I also might mention that unlike, Rohit is not a lawyer. Rohit is a finance guy. He worked at McKinsey as a consultant for 2 years, but he's just as sharp as any lawyer on rules if he puts his mind to it. So, and he's very energetic. I think that he's going to do a lot of stuff, and it's going to be thoughtful and tactical with a broader strategic vision. What specifically will he work on? Well, I don't want to say that I know, because I'm teaching now. I don't know what Rohit's talking about doing. But with the asterisk, this is all speculation on my part. So take it for what it's worth, which is probably not too much. I think that off the top of the list, I think one change will be that in the enforcement office, there will be a renewed focus on ensuring that the cases provide remediation back to consumers. And Brian, we can talk about this if you want, but I tracked the enforcement cases fairly carefully, and there were still quite a few cases that were coming along, but the overall amount of redress, restitution, or disgorgement, however you want to characterize it, being returned to the pockets of consumers declined, I think, pretty steeply in the last administration. I would anticipate that Rohit will insist that the cases provide remediation before he agrees to settle them, and will probably pursue pretty aggressively ensuring that customers get their money back. So second, some things that Nancy's rundown of what's going on at the Bureau right now in many ways overlaps what I anticipate will probably continue to happen if Rohit is confirmed. I agree that there'll be a continuing focus on racial justice and systemic inequality, one of the great issues of our time. And what that means, I think that I would anticipate that Rohit will be searching and creative and trying to find different tools to address that, both obviously Equal Credit Opportunity Act cases and supervision. But I also would think that there will be a focus on non-English language content and disclosures and an outreach to consumers. And I also agree with Nancy that automated valuation and appraisals is an interesting area where we might be able to provide some greater wealth by just recharacterizing how we're talking about the value of homes in minority zip codes. So those all seem to me like likely avenues for advance. I also think that this might be too obvious, but Rohit was the first student lending ombudsman at the CFPB and ran the student lending office, and he has a very high level of knowledge about student loan servicing, and I think that we can expect that there will be a renewed focus on that. There are still, from the perspective of people like me, who spent their careers focusing on consumer advocacy, we view the student loan servicing market to be quite dysfunctional. Things like the failure to provide public service student loan debt forgiveness, adequate transition into income-driven repayment plans for student loan borrowers that are struggling to repay their debts. These are existing legal programs that were adopted by the United States Congress and implemented into law, but still do not appear to be delivered adequately to student loan borrowers across the country. I think that you can expect that Rohit will want to see some action on that, and will attempt to use the Bureau's tools to deliver concrete results in that marketplace. I should stop and turn over to Todd, but maybe just a couple more things. I think he's going to continue to insist on high functioning in the student loan servicing market. When they're transition between servicers, dealing with the COVID-related servicing challenges. Folks that are running mortgage servicing markets need to stay on their game and make sure that customers are being taken care of. And then the last thing I'll mention, and I'll stop, Nancy also talked about it, but a real wild card is what happens with COVID. If it continues to decline, we may be transitioning away from that, and that may not see too much, but there's also been resurgence with the various variants, and whether or not, if there are major breakthroughs in the vaccines, or if we continue to see large populations of America not accepting the science on vaccines, we could see a lot of consumer harm from that disease, and that's going to creep into their consumer financial arrangements with their banks, their credit unions, and whatnot. And a lot to talk about that. I wrote a paper about it with Director Cordray and Diane Thompson, who is still at the agency, at the Bureau. Lots of details on that, but I know I need to stop and turn it over to Todd.
Yeah, Todd, let me jump in here, and I'll throw you a curveball. So this occurred to me in the context of our discussion here, which is Nancy laid out, the roadmap for what the agency has articulated as, its policy direction, and Chris laid out, his well caveated guess about the direction of, where Mr. Chopra might go if confirmed. The question that came to my mind, which I think you're in a good position to answer, is, does it really matter anymore? And what I mean by that is, post Seila Law, where the director can be removed at will by the president, does it matter so much what the director's policy preferences and priorities are, or does it, over time, does the agency begin to act more like an executive agency, and does the agency kind of get subsumed within the meta government infrastructure where rules are run through OIRA, where I know you worked at one point, and does the policy development process start being mandated through the White House, through NEC, and downstreamed to the Bureau? And so, are the activities, if we're trying to read the tea leaves and understand where the agency is going, I guess the other way of asking this question is, should we start, thinking what are the administration's main priorities and figure out where the Bureau fits into that agenda, as opposed to what used to be, I think, supreme in the CFPB criminology, which is figuring out what makes, an individual director tick, and what can we expect based off of their unique histories and background and interests. So I'm riffing a little bit here, but, what do you think, happens with the agency post Seila? Is it inevitable that they get pulled more into an executive agency posture, or are they going to hold tight and be treated as the independent agency that they were conceived to be?
Wow, that's a marvelous question, Brian. It certainly is a curveball. Before I answer that, first, I want to say congratulations to you for this slate of panels today in the Federalist Society, which has been fascinating to hear Director Kraninger, and then Tom Paul and David Silberman and my colleagues on this panel. I couldn't help but laugh when Chris said he gets impatient in meetings at his career choice to become a faculty member. Apparently, he didn't know about faculty meetings when he signed up for that career choice.
I've had a lot of angst about that, Todd. Go ahead.
There you go. There's deception, that cause of action for deceptive. That's a great question, Brian. And as you were asking the question, I was trying to recall whether there's any historical precedence for this, which is we know during the 70s that and into the 80s that some independent agencies were reformed, some were abolished. The ICC was abolished, for example. Interstate Commerce Commission, I think many of its duties were merged into the Department of Transportation, as was the case with the Civil Aeronautics Board. Obviously, the FAA is a successor to that, and I'm not an expert on it, but it's a great question. I think it raises a couple questions, which is first that the agency, it's an unusual agency in that it is structured very much like an independent agency in its internal guts, right? I mean, the fact that it has this well-developed administrative procedure process, the fact that that its budget is protected by Congress, of course, from Congress, which is sort of, and technically the president, which is a sort of a super independence type thing. From the beginning, it's always been sort of a peculiar way to think about this as it becoming an independent, as an executive agency, given so many of the features that structure like an independent agency, like I'm saying. It's also unusual. I was very struck by an observation that Director Kraniger made in her discussion with you, Brian, which is the way in which not just the budget, but also the fact that the only political appointment technically in the agency is the director influences the relationships between the director and the Hill, in that, as she mentioned, there's a lot of negotiation that goes on when you need to get your sub-cabinet appointments confirmed. Often that's a time for back and forth between the Senate and a department. So in that sense, Congress still, the Senate largely lacks that tool still for oversight. It's unclear how things are going to shake out on the budget. It's a very murky area at this point, which is what happens if still, the statute provides that the budget is provided from the Federal Reserve. But what happens if the White House tells the director, we want you to request X in your budget, and the director fails to do that? Obviously, it could be removed for that. But the Dodd-Frank legislation is kind of murky on what the technical authority is of the White House and the OMB over all of that. Obviously, the final thing is that this has been a very independent agency. They've tenaciously protected the independence of the agency, and the DNA is very much of an independent agency. The pattern of relationships between the agency and the Hill is kind of part of that legacy. And so I think seeing how that develops over time is going to be very interesting. The extent to which, as you suggested, you would expect it would come to act more like an executive agency over time. But given this sort of long run up and this fierce assertion of independence that we've seen from this Bureau from the beginning against both in theory, the president as well as the Hill, it may take longer to kind of digest this agency into the executive branch than might otherwise be the case. And that's one of the things I think is going to be interesting to watch here, is not just the development of relationships with the White House, but development of relationships with Congress. Obviously, Director Chopra is known to be very closely allied with Senator Warren, as was Director Cordray. And what will that influence be like with his views on the Hill? I think another interesting thing that I'm going to be interested in watching is what will be the relationship, and I think Nancy may have alluded to this, but the relationship between the CFPB and the FTC. which is that's been a very unsettled relationship over time. The CFPB during the Cordray term was relatively expansionist and imperialistic. And I know from my discussions with people at the FTC that ruffled some feathers. And in many ways, the chair of the FTC at that time kind of went along with that. The CFPB was kind of the cool kid in town. And there wasn't a lot of political gain to be had to standing up to the FTC at that point. And so questions like the, extending the CFPB's jurisdiction indirectly over auto dealers, for example, I know is something that rankled a lot of feathers at the FTC and has kind of been pared back during Director Kraninger's term. I think this will be especially interesting to watch given the sort of surprise appointment of Lena Khan as the chairman of the FTC, in that she has very little background in consumer protection. Obviously, she's known for her work in competition. She also has very little experience within sort of the, let's face it, knife fighting of sort of interagency relationships that goes on in the federal government. And so,
not to interrupt you, but if there's anybody who's maybe well positioned to bridge that gap between FTC and CFPB, I'd have to guess it's a sitting commissioner who's the presumed, soon to be confirmed director for the Bureau. So I know there has been kind of a tension in terms of how the agency holds hands behind the scene on joint kind of collective actions. My guess is that there's probably an established relationship there, and maybe a smooth relationship. So apologies for interrupting there. I do want to make sure that we have time to talk about the other major question that I have here about the future of the Bureau, which is we've explored in some detail where we think the agency is going, at least in the near term. It's a wholly separate question on where should the agency go, and to some extent, beauty's in the eye of the beholder. If public observation of past Bureau activities is any indication, I strain to find a middle ground. You either hate it or you love it, depending on who's in control. And there seems to be not any kind of moderating middle right now, and maybe that's just a feature of the politics we're in. But I do think that there is important thinking that should take place 10 years out, evaluating where the agency is on its future. Both Kathy and then David and Tom all spoke to the idea of trying to depoliticize the agency and in some way get to regular order. And so, I think one way you do that is internal cultural change, but importantly, you should have a vision of what the not end state is, but where the agency is going. And I know, Todd, in full disclosure, I had a hand in the task force effort, but that culminated, under your leadership in a series of recommendations for the future. Professor Peterson, I know you've written extensively about, kind of hot button consumer protection issues, and have done a lot of deep thinking about where in the development of federal consumer financial law or consumer protection law and regulation generally, with a state federal interplay should go. So I'd be remiss if I didn't try and tap into your expertise in thinking on, what would be, your vision for how things should shape up, say, in the next 10 years. So brand new agency, went through the fits and starts of becoming a mature agency. Now that it has all of its resources, capabilities, faculties, has developed in-house expertise. Where do you see it going, or where should you see it going? And, Chris, I'd love to kick this to you first, and then maybe turn it over to Todd and Nancy for reaction or for additional thought.
Well, first, I agree that in Washington, there's still a lot of, it's obviously a football and the partisan war. But one thing you didn't mention in my bio, I was the Democratic Party's candidate for governor of Utah in the last election cycle. And so I spent a lot of time out in the hinterland, going around a very conservative, very Republican state. Obviously, I lost. I mean, it's Utah. I'm a Democrat. But I did get more votes than any Democratic candidate in the history of Utah. And what I found was that people really weren't too offended that I was a former CFPB guy. And when I started talking about consumer finance, the thing that Republicans agreed about, at least in my home state, was that we needed payday loan reform. A super majority of Utahns, of all people, support a traditional interest rate cap. And that's true all across America, which is far on the interventionist side from the most aggressive version of what the CFPB was proposing. I think that payday loan reform is right in the wheelhouse of the kind of thing that the CFPB was supposed to do to protect consumers from financial products that are not probably in their best interest most of the time. And obviously there's going to be disagreement with that on the panel. This is a normative thing. I think we need aggressive reform of that industry. Second, I actually...
I don't, yeah, sorry to interrupt. Do you see that more as a state level or at the CFPB specifically?
Yeah, I mean, both. I think that either some, I mean, it's not in my state, it's not happening, even though a super majority of Republican primary voters want it. It doesn't seem to happen. And there are a lot of complicated reasons for that. I'd like to see it at the federal level and the state level, or either. It'd be great if Congress would do something. I have a bill I drafted that's likely to be introduced, I think, by Senator Brown pretty soon, if it hasn't already. But in any event, I also, my second thing I'd like to say is actually it's consistent, I think, with what Todd was saying and what you mentioned, Brian, with the Supreme Court's decision in the AMG versus FTC case. The FTC is going to have real problems in providing consumer redress, but the CFPB still has very robust tools about that. I'm really hoping that Rohit, Director, soon to be, I hope, Director Chopra will work on collaborative CFPB FTC enforcement to try to leverage those boots on the ground at the FTC to make sure that they can still deliver real benefits back to American consumers. I envision. And look, I realize this is going to take some collaboration, but I envision, FTC litigation teams that are mated with CFPB litigation teams, where FTC is driving some of the investigative work, and CFPB folks are being brought in to make sure that the remediation is happening back to consumers. Third thing I'll mention. I'm very worried about cybersecurity. I'm concerned that in Russia, Ukraine, maybe some other places, there are quasi-state actors that are, engaged in criminal activity, seizing computers in the United States. And if they manage to get into our financial institutions, that's going to run right up into the consumer protection laws that we have had for generations. And this is an area where we could have consensus. We need, banks want to have, and credit unions, other non-bank financial service providers want to have secure systems. And if they don't have secure systems, if they're getting hijacked, then it's the customers who are going to be in real trouble. We need to be proactive in trying to address that. And that could mean collaborative relationships with the State Department. And we need to have a bold vision for how to secure our financial systems to protect consumers and industry. Fourth thing I'll mention, I think that I am very concerned about where we're headed with respect to climate change and the nation's financial industry. We have in our country, one of the great inventions of American society is the 30-year fixed interest rate mortgage. It helped build our middle class after the New Deal, where the basic deal is this: if you're about 30 years old, 35 years old, you've got enough money to make a down payment on the house, you can, over the course of your lifetime, with a low fixed interest rate loan, manage to acquire property and become part of the landed gentry and leave that to your progeny by the end of your working life when you retire. But the problem now is that the best scientists that focus on this believe that in 30 years, 50 years, 60 years, and nobody knows for sure, much of our seaboard is going to start to go underwater, and we're already starting to see that with the collapse of a tower in Miami on Miami Beach. Do we need disclosures on that? How are we going to deal with 30-year fixed interest rate mortgages, one of the greatest inventions we've ever had, still being made on property that is likely to be underwater in the foreseeable future, perhaps within the due date of the promissory note that the consumers are signing? Last thing I'll say, and I gotta stop turning over. I think that my normative point is that we need to move fast. Ordinary consumers do not understand why it takes so long for rules, for enforcement cases, for changes in policy to be enacted. Already we're well into the 2-year policymaking cycle, and the director's not even confirmed yet. And I know it feels like a lot of stuff's going on for people who are watching inside the Beltway, but out in the provinces, people aren't really feeling a lot of this. They don't understand. They don't see that changes in their daily lives are being made. Rohit needs to move fast to make concrete decisions, try to deliver value to the American public. I'll stop.
Chris, I'll just note before turning over to Todd, I was really struck by your notion of the integrated FTC, CFPB activities. You might want to work on a paper with Todd, because I think he's spoken to the notion of combining the two agencies. So maybe there's some common.
Todd and I, we get in a fight as soon as we start talking. I don't know if it's possible. It'd be an interesting paper if we could manage to sort it out.
So Todd, you obviously chaired the task force, which I think is, at least in recent years, the kind of definitive, kind of forward-looking statement about consumer financial law and policy. I know folks are reacting to that, agree, disagree, et cetera. But would love your take on where you think CFPB policy development should go, what you envision, the next 10 years, say, of CFPB activities. Where should things be headed?
Sounds good. Well, I've got 101 ideas of recommendations, so I'll just mention a few. The first is one of the things we call for in the task force report is, and Tom Paul touched on this, so I won't belabor it, is sort of thinking coherently about tool usage, which is the CFPB is an unusual, and as far as I can tell, unique institution for consumer protection bureau in the world, in that it has 5 tools: enforcement, supervision, regulation, consumer education, and research. And as Tom Paul touched on, it's not always been clear the way that whether the CFPB has thought strategically about how to use all those tools in combination. And related to that may be a consideration of internal reorganization, perhaps around markets rather than around tools, which is something that we suggest in the task force as well, which is thinking about a problem from the perspective of how consumers shop for a product and how markets work, and then thinking about what the right tool is to do that. Whereas what Tom suggested, it seems like sometimes they pick a tool and then decide kind of work backward from there as to how the issue will be approached. I think a second thing is that Director Kraninger touched on that I want to endorse very much is she pointed to the innovation agenda of the Bureau over the last few years, headed up by Paul Watkins in particular, which got started on Director Cordray. I think that is a hugely important thing in order to promote not just innovation, but innovation for the purpose of promoting financial inclusion and competition. And related to that, as well as I strongly endorse the point that in the White House EO about promoting competition in bank accounts, except that I might say maybe it doesn't go far enough. I'm not sure that sort of just portability of account information is enough. I would like to see more. Perhaps really thinking about how to create a more fluid banking system that makes it easier for people to change accounts, much like they can change credit cards and prepaid cards right now. And I think that would promote greater competition and perhaps make banks more responsive to consumers and create more innovation in that market. We also talk about just generally about competition and strengthening The Dodd-Frank tells the Bureau to take account of the impact of their rules and practices on competition. And we have a number of our recommendations. I think that is something that should be elevated within the Bureau. And hopefully Director Chopra, who comes from the FTC and is used to the idea of thinking about the interface between competition and consumer protection, he may be able to think about how to effectuate that policy of competition. A final thing that I think would be useful to think about, and one of the points we called for is, and this relates to the tools usage question, which is we suggest greater reliance on principles-based regulation, as well as being more proactive in terms of crisis management, which is to say, in the past 20 years, we've had three major crises that have affected consumers, Y2K, the 2008 financial crisis, and now, of course, the pandemic. And I think the federal regulators did a great job using the tools at their disposal and sort of making things work through COVID. But I think it might be useful to have the regulators themselves kind of stress test their mechanisms, and perhaps have Congress grant greater authority to the agencies to respond. So, for example, a lot of states have a lot of special interest provisions that protect notaries and require in-person real estate closings and all this sort of stuff that were obviously a disaster during the pandemic, and the FTC managed to cut through that while you were there, Brian, I believe, and it did a great job with that. But it would be nice if there were greater provisions for that, as well as principles-based regulation. In terms of writing these long, detailed, prescriptive regulations, think about how to use regulation perhaps in a more integrated way with supervision and rulemaking, supervision, research, and the like. And I'll turn it over to Nancy to bring us home.
Yeah, Nancy, I'll give you the last word. I mean, you've obviously been a close observer of the Bureau and consumer finance topics generally, even before the Bureau. You know, what would you like to see, come from the Bureau, be it from a client perspective or a business need perspective or a personal perspective?
Yeah, no, thank you. I mean, I agree with a lot of what, Chris and Todd have said. And from my perspective, look, I advise clients on these issues all the time, but I'm also a consumer. And, and I use my consumer hat, and it kind of instructs me on how I advise my clients and how I think about these issues. So, I'll just highlight too. I think this question we probably can talk about for hours, if not days. But two that are top of mind for me is one, clear rules of the road. So, companies really want to do the right thing. And a lot of times they're just like, yeah, but we're not even sure. And I can give two, very timely examples. One has to do with credit reporting for borrowers who exit forbearances, who for whatever reason decide not to engage in some sort of permanent loss mitigation option. The CFPB's provided guidance in an FAQ 10 that is just really unclear, doesn't address the situation, despite numerous attempts to seek clarity from trade groups and others. They just declined. So they leave companies just not knowing what is the right thing to do there, and which, rather than a gotcha mentality, it would be really nice to give clear guidance when a specific issue has been presented. The second example I can say is the Hunstein case that came out of the 11th Circuit recently that discusses with regard to debt collectors, what information you could use to have service providers conduct or not without violating the FDCPA. Again, the issue is not clear, and the Bureau declined to provide guidance. And maybe that one's a little different when there's active case law. But again, I think, now we have, a circuit case that's, the law in, 3 states that are subject to the 11th Circuit. It would be nice to have guidance there. So clear rules of the road would be number one. Number two would be I do like the idea of coordinated regulation and enforcement between the federal and the states. But in my experience, what it turns to is, particularly with non-banks, is now you have 54 regulators all looking at the same thing. So it makes it really expensive for companies, and that just gets passed down to consumers. So, federal preemption has been kind of, I would say, out of style in the last several years since the Dodd-Frank Act that amended the preemption standard. And I think that's something that needs to be revisited on how we can ensure that there is adequate consumer protection, but not making it so uncostly for companies to do business and trying to deal with 54 regulators. So.
Well, I think we have hit our mark almost exactly. I have 2:59. Thank you, Todd. Thank you, Chris. Thank you, Nancy, so much for joining me on this panel. And thanks to the audience for joining the entire conference today. And thanks especially to the Federal Society for hosting today's event. This now concludes the conference. Thank you very much.
Thank you.